Other privileged communications not found in the Rules of Court. 1. Sec. 24 of Rule 130 deals with the types of disqualifications by reason of privileged communication, to wit: A. Communication between husband and wife, B. Communication between attorney and client, C. Communication between physician and patient, D. Communication between priest and penitent, and E. Public officers and public interest. 2. There are, however, other privileged matters that are not mentioned under Rule 130. Among them are the following. A. Editors may not be compelled to disclose the source of published news, B. Voters may not be compelled to disclose for whom they voted, C. Trade secrets, D. Information contained in tax census returns, and E. Bank deposits. Air Philippines v. Penzwell, Inc., 540 SCRA 215. 3. Under Art. 233 of the Labor Code of the Philippines, information and statements made at conciliation proceedings shall be treated as confidential. 4. Under Sec. 6 of ROA.9194, amending Sec. 9 of RA 9160, Anti-Money Laundering Act of 2001, institutions covered by the law and its officers and employees who communicate a suspicious transaction to the Anti-Money Laundering Council, are barred from disclosing the fact of such report, that such report was made and other related information. C. Examination of witnesses. Open court examination, exceptions. 1. Sec. 1 of Rule 132 provides for the examination of the witness in open court and, unless the question calls for a different mode, the answer of the witness shall be given orally. This method allows the court the opportunity to observe the demeanor of the witness and also allows the adverse party to cross-examine the witness. 2. There are, however, testimonies which need not be given orally in open court. Under the Rule on Summary Procedure, in criminal cases, the affidavits of the parties shall constitute the direct testimonies of the witnesses who executed the same. Sec. 15, Rule on Summary Procedure. In civil cases, the parties are merely required to submit the affidavits of their witnesses and other pieces of evidence on the factual issues, together with their position papers, setting forth the law and the facts relied upon. Sec. 9, Rule on Summary Procedure. 3. Likewise, depositions need not be taken in open court. They may be taken before a notary public. Sec. 10 Rule 23, Rules of Court, or before any person authorized to administer oaths. Sec. 14 Rule 23, Rules of Court. 4. In a criminal case, either party may utilize the testimony of a witness who is deceased, out of the country, unavailable or unable to testify despite the exercise of due diligence, even if the testimony was one used in another case or proceeding, judicial or administrative, provided the said proceeding involved the same parties and subject matter and the adverse party had the opportunity to cross-examine the witness. Sec. 1F, Rule 115, Rules of Court. 5. Under the Judicial Affidavit Rule, the judicial affidavit shall take the place of direct testimonies of witnesses. Sec. 2, Judicial Affidavit Rule. Oath or affirmation. 1. The witness must take either an oath or an affirmation. Sec. 1 Rule 132, Rules of Court, but the option to do so is given to the witness and not to the court. 2. An oath is an outward pledge made under an immediate sense of responsibility to God or a solemn appeal to the Supreme Being in attestation of the truth of some statement. Black's Law Dictionary, 5th ed., p. 966. An affirmation is a substitute for an oath, and is a solemn and formal declaration that the witness will tell the truth. Ibid. 55. 3. Where the witness refuses to take an oath or give any affirmation, the testimony may be barred. U.S. v. Fowler, 605 F. 2d 181, 5th CIR 1979. Examination of witnesses and record of proceedings. Bar 1978. 1. The examination of witnesses presented in a trial or hearing shall be done in open court and under oath or affirmation. The answers of the witness shall be given orally except if a. The witness is incapacitated to speak, or b. The question calls for a different mode of answer. Sec. 1 Rule 132, Rules of Court. 2. The questions propounded to a witness and his answers thereto shall be recorded. Also to be recorded are the statements made by the judge, any of the parties or any of the counsels. In fact, the entire proceedings of the trial or hearing must be recorded. The recording may be by shorthand, stenotype or any means of recording found suitable by the court. See Sec. 2 Rule 132, Rules of Court. 3. The official stenographer, stenotypist or recorder shall make a transcript of the record of the proceedings and shall be certified by him as correct. The transcript so prepared and certified shall be deemed prima facie a correct statement of such proceedings, sets a 2 Rule 132, Rules of Court. Rights and obligations of a witness, bar 1998, 2004, 2005. 1. As a rule, a witness has an obligation to answer questions, although his answer may tend to establish a claim against him. Sec. 3 Rule 132, Rules of Court. Of course, there are questions which he is not bound to answer. This is because a witness has certain rights like a. Not to give an answer which will tend to subject him to a penalty for an offense, b. To be protected from irrelevant, improper, or insulting questions, and from harsh or insulting demeanor, c. Not to be examined except only as to matters pertinent to the issue, d. Not to be detained longer than the interest of justice requires, and e. Not to give an answer which will tend to degrade his reputation, unless it be the very fact at issue or to a fact from which the fact in issue would be presumed. Sec. 3 Rule 132, Rules of Court. 2. Foremost among the rights of a witness is the right not to give an answer that will subject him to a penalty, unless otherwise provided by law. Sec. 3-4, Rule 132, Rules of Court. This provision in the Rules of Court gives meaning to the right of a person against self-incrimination. Sec. 17, Art. .111, Constitution of the Philippines. Note, however, that under RA 6981, Witness Protection, Security and Benefit Act, a witness admitted into the Witness Protection Program cannot refuse to testify or give evidence or produce books, documents, records or writings necessary for the prosecution of the offense or offenses for which he has been admitted on the ground of the right against self-incrimination. Sec. 14, RN 6981. 3. Aside from the right against self-incrimination, a witness likewise has the right not to give an answer that will tend to degrade his reputation. However, even if the answer tends to degrade his reputation, he must answer the question if the degrading answer a. is the very fact in issue, or b. refers to a fact from which the fact in issue would be presumed. Sec. 3-5, Rule 132, Rules of Court. But a witness must answer to the fact of his previous final conviction for an offense. Ibid. 4. If the witness is the accused, he may totally refuse to take the stand. A mere witness cannot altogether refuse to take the stand. Before he refuses to answer, he must wait for the incriminating question. Bagadiong v. Gonzalez, 94 SCRA 906. 5. Counsel must always come to the aid of his witness being subjected to intimidation, harassment and embarrassment. Such acts are objectionable and a timely objection should be raised. Examination of a child witness, live link television, bar 2006. 1. The examination of a child witness presented in a hearing or any proceeding shall be done in open court. The answer of the witness shall be given orally, unless the witness is incapacitated to speak, or the question calls for a different mode of answer. Sec. 8, Rule on examination of a child witness. The examination in this provision does not refer to the competency examination of the child pursuant to Sec. 6 of the same rule, but to a situation where the child is already testifying in court. Under Sec. 6c, only specified persons are allowed to attend the competency examination of the child and is obviously not an open court examination. When the child is testifying, the court may exclude the public and persons who do not have a direct interest in the case, including members of the press. The order shall be made if the court determines on the record that to testify in open court would cause psychological harm to him, hinder the ascertainment of truth, or result in his inability to effectively communicate due to embarrassment, fear or timidity. The court may also motu proprio exclude the public from the courtroom if the evidence to be produced during trial is of such character as to be offensive to decency or public morals. The court may also, on motion of the accused, exclude the public from trial, except court personnel and the counsel of the parties. Seco 23, Ibid. The court may also order that persons attending the trial shall not enter or leave the courtroom during the testimony of the child. Sec. 24, Ibid. 2. When a child does not understand the English or Filipino language or is unable to communicate in said languages due to his developmental level, fear, shyness, disability, or other similar reason, an interpreter whom the child can understand and who can understand the child may be appointed by the court, motu proprio or upon motion, to interpret for the child. Sec. 9 a. Ibid. Being another witness in the same case or a member of the family of the child is not in itself a disqualification. Such a person may be an interpreter if he is the only one who can serve as interpreter. If the interpreter is also a witness, he shall testify ahead of the child, sec. 91b, ibid. 3. If the court determines that the child is unable to understand or respond to questions asked, the court may, motu proprio or upon motion, appoint a facilitator. The facilitator may be a child psychologist, psychiatrist, social worker, guidance counselor, teacher, religious leader, parent, or relative, sec. 10, ibid. 4. A child testifying at a judicial proceeding or making a deposition shall have the right to be accompanied by one or two persons of his own choosing to provide him emotional support. Said support persons shall remain within the view of the child during his testimony. One of the support persons may even accompany the child to the witness stand, and the court may also allow the support person to hold the hands of the child or to take other appropriate steps to provide emotional support to the child in the course of the proceedings, but the court shall instruct the support persons not to prompt, sway, or influence the child during his testimony, sec. 11, ibid. The support person may be another witness, but the court shall disqualify him if it could be sufficiently established that the attendance of such support person would pose a substantial risk of influencing or affecting the content of the testimony of the child. If the support person who is also a witness is allowed by the court, he shall testify ahead of the child, sec. ibid. 5. An application may be made for the testimony of the child to be taken in a room outside the courtroom and be televised to the courtroom by live-link television. The application may be made by the prosecutor, counsel or guardian ad litem at least 5 days before the trial date, sec. 25 ibid. The court may order that the testimony of the child be taken by live-link television if there is a substantial likelihood that the child would suffer trauma from testifying in the presence of the accused, his counsel or the prosecutor, as the case may be. The trauma should be of a kind which would impair the completeness or truthfulness of the testimony of the child, sec. 2511, ibid. Bar 2006. If the child is testifying by live-link television and it is necessary to identify the accused at trial, the court may allow the child to enter the courtroom for the limited purpose of identifying the accused, or the court may allow the child to identify the accused by observing his image on a television monitor, sec. ibid. 6. The testimony of the child shall be preserved on videotape, digital disc, or other similar devices which shall be made part of the court record and be subject to a protective order, sec. 25th, ibid. 7. To shield the child from the accused, the court may allow the child to testify in such a manner that the child cannot see the accused by testifying through one-way mirrors, and other devices, sec. 26, ibid. 8. Records regarding a child shall be confidential and kept under seal. Except upon written request and order of the court, a record shall only be released to the following. 1. Members of the court staff for administrative use, 2. The prosecuting attorney, 3. Defense counsel, 4. The guardian ad litem, 5. Agents of investigating law enforcement agencies, and 6. Other persons as determined by the court, sec. 3110, ibid. 9. Whoever publishes or causes to be published in any format the name, address, telephone number, school, or other identifying information of a child who is or is alleged to be a victim or accused of a crime or a witness thereof, or an immediate family of the child shall be liable to the contempt power of the court, sec. 31d, ibid. 10. Where a youthful offender has been charged before any city, or provincial prosecutor or any municipal judge and the charges have been dropped, all the records of the case shall be considered as privileged and may not be disclosed directly or indirectly to anyone for any purpose whatsoever. If he is charged and acquitted or the case is dismissed, the records are also privileged, as a rule, sec. 31g, ibid. 11. The youthful offender, who fails to acknowledge the case against him or to recite any fact related thereto in response to any inquiry made to him for any purpose, shall not be held under any provision of law to be guilty of perjury or of concealment or misrepresentation, sec. 31g, ibid. Kinds of examinations. 1. Direct examination. This is the examination in chief of a witness by the party presenting him on the facts relevant to the issue, Sec. 5 Rule 132, Rules of Court. It is actually a procedure for obtaining information from one's own witness in an orderly fashion. It is information which counsel wants the court to hear. The purpose is to elicit facts about the client's cause of action or defense. This examination is now subject to the judicial affidavit rule, which took effect on January 1, 2013. The rule is discussed at the end of this chapter. 2. Cross-examination. This is the examination of the witness by the adverse party after said witness has given his testimony on direct examination. As a rule, the scope of the cross-examination is not confined to the matters stated by the witness in the direct examination. Thus, under the rules of court, an objection that the question in the cross-examination is on a matter not touched upon by the witness in his testimony will seldom be sustained provided the question covers matters allowed to be asked by way of cross-examination. This is because the rule allows questions designed to test the accuracy and truthfulness of the witness, his freedom from interest or bias, or the reverse, and to elicit all important facts bearing upon the issue. Sec. 6 Ibid. Although Sec. 6 of Rule 132 allows the cross-examiner a wide latitude in asking his questions, this provision merely states a general rule. Where the witness is an unwilling or a hostile witness is so declared by the court, he may be cross-examined only as to the subject matter of his examination in chief. Sec. 12 Ibid. The same limited scope of a cross-examination is imposed upon the cross-examiner where the witness examined is an accused because he is subject to cross-examination on matters covered by the direct examination. Sec. L.D. Rule 115, Rules of Court. Cross-examination has two basic purposes, namely a. to bring out facts favorable to counsel's client not established by the direct testimony, and b. to enable counsel to impeach or to impair the credibility of the witness. 3. Redirect examination. This examination is conducted after the cross-examination of the witness. The party who called the witness on direct examination may re-examine the same witness to explain or supplement his answers given during the cross-examination. It is the examination of a witness by the counsel who conducted the direct examination after the cross-examination. In re-direct examination, the counsel may elicit testimony to correct or repel any wrong impression or inferences that may have been created in the cross-examination. It may also be an opportunity to rehabilitate a witness whose credibility has been damaged. In its discretion, the court may even allow questions on matters not touched in the cross-examination. Sec. 7 Rule 132, Rules of Court. 4. Re-cross-examination. This is the examination conducted upon the conclusion of the redirect examination. Here, the adverse party may question the witness on matters stated in his redirect examination and also on such matters as may be allowed by the court in its discretion. Sec. 8 Ibid. Death or absence of a witness. 1. If the witness dies before his cross-examination is over, his testimony on the direct may be stricken out only with respect to the testimony not covered by the cross-examination. The absence of the witness is not enough to warrant striking out his testimony for failure to appear for further cross-examination where the witness has already been sufficiently cross-examined, and the matter on which the cross-examination is sought is not in controversy. People v. Sonaris, 99 SCRA 92. 2. If the witness was not cross-examined because of causes attributable to the cross-examining party and the witness had always made himself available for cross-examination, the direct testimony of the witness shall remain in the record and cannot be ordered stricken off because the cross-examiner is deemed to have waived the right to cross-examine the witness. De La Paz v. Intermediate Appellate Court, 154 SCRA 65. Recalling a witness. If a witness has been examined by both sides, the witness cannot be recalled without leave of court. Recalling a witness is a matter of judicial discretion. In the exercise of its discretion, the court shall be guided by the interests of justice. Sec. 9 Rule 132, Rules of Court. Leading questions. 1. A leading question is one that is framed in such a way that the question indicates to the witness the answer desired by the party asking the question. In the words of Sec. 10 of Rule 132, it is a question which suggests to the witness the answer which the examining party desires. 2. Leading questions are not appropriate in direct and redirect examinations, particularly when the witness is asked to testify about a major element of the cause of action or defense. Leading questions are allowed in cross and re-cross examinations. In fact, leading questions are the types of questions that should be employed in a cross-examination. Such questions enable the counsel to get the witness to agree with his client's version of the facts. Most lawyers will agree that a why question should not be asked in cross-examination. This kind of question allows a witness to explain his or her position, emphasize key points of harmful testimony and control the pace and scope of the examination. It invites the witness to deliver an unwanted lecture in the courtroom. Short and leading questions will help control the witness. 3. Leading questions are, however, allowed in a direct examination in the following instances. A. On preliminary matters. B. When the witness is ignorant, or a child of tender years, or is feeble-minded or a deaf-mute and there is difficulty in getting direct and intelligible answers from such witness. C. When the witness is a hostile witness, or D. When the witness is an adverse party, or an officer, director, or managing agent of a corporation, partnership or association which is an adverse party. Sec. 10 Rule 132, Rules of Court.